Imagine a company publicly promises to pay you money. You follow all their instructions, and when you claim the reward, they say, "Hey, we were just joking." Can they get away with it? Let's find out. Hi, I am Prasad. Welcome back to One Section at a Time. In today's episode, we step away from sections for a moment and explore one of the most famous cases in contract law, that is Carlill versus Carbolic Smoke Ball Company, 1893 case. The story was back in the 1890s, a company called Carbolic Smoke Ball Company advertised a product that claimed to prevent influenza. Their advertisement said, "We will pay £100 to anyone who uses our smoke ball as directed and still catches the flu." Sounds bold, right? They even added, £1,000 is deposited in the bank to show our sincerity. Enter Mrs. Carlill. Mrs. Carlill saw the advertisement. She bought the smoke ball, used it exactly as instructed, and still got sick. So she claimed the £100 that was agreed by the company or advertised by the company. However, the company refused. The company argued that this was just an advertisement, not a serious offer. There was no formal acceptance and there was no contract. Basically, what the company meant was, we didn't really mean it. Alright. However, the court's decision, and this is very important, and that's why it becomes a landmark case in the contract law. The court disagreed, and this is where things get very powerful. The court held that it was a valid offer. The advertisement was clear, definite, and serious, especially because money was deposited in the bank and the company also said so. Acceptance by the conduct. Mrs. Carlill did not write back. By simply using the smoke ball as instructed, she accepted the offer. So this is acceptance by conduct is valid. Consideration was present. She bought the product, she used it as instructed. This was a sufficient consideration. And hence a binding contract was formed, and the court decided that the company was legally bound to pay £100. So this is a very important and interesting case law which is cited right at the beginning of the studies in contract law. So what the legal principles that were evolved in this case? A general offer can be made to the public. Acceptance can happen through conduct. Advertisements can sometimes be legally binding. Intention matters, and actions speak louder than words. So this is again, as I mentioned, one of the most cited cases in contract law. It helps us understand offer, acceptance, consideration, intention. All of this was a part of the Carlill and Carbolic Smoke Ball Company Limited. Sometimes what looks like an advertisement is actually a legally binding promise. So we need to be very clear, or companies nowadays have to be very clear when they do advertisements. Are they actually making an offer or not is what they need to be careful about. If you have enjoyed this story, share it with someone who thinks ads are always harmless. Follow One Section at a Time for more such case laws and legal concepts explained simply. In the next episode, we will see when is consideration not required and the exceptions everybody must know. Until then, keep learning, keep questioning, and keep listening. Thank you.